Good morning, sir. You're Herbert DeBlanc,
Yes, ma'am.
and will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. DeBlanc, in cause number 22-40044, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements. That's from February 19th of 2021. Count 2 alleges that you were previously convicted of failure to comply with sex offender registration requirements, a second-degree felony, September 10th of 2015. And how do you plead to that charge? And is that prior offense true, conviction? And are you entering your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand that? And do you understand if I follow the agreement that you've made with the district attorney, you will be waiving or giving up any right to appeal? And do you also understand if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. DeBlanc is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of failure to comply with sex offender registration requirements. Find that prior conviction true. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. Good luck to you, sir. You can go back with the bailiff. Thank you. You too, sir.
He just actually like the very nice delay.
Yeah.
And he was registered. He was just in jail and out of jail.
Jesse Griffin, Mr. Parker.
Good morning.
Good morning. Good morning, sir. Are you Jesse Griffin?
Yes, ma'am.
And Mr. Griffin, in cause number 25 DCCR 1397, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 28th of 2025. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And I have here on the tablet a document, plea bargain rejection, that has your signature on it with Mr. Parker's, that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for an 8-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to enter a plea. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. Mr. Griffin, Mr. Parker has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Parker, you're released. Mr. Griffin, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff. Brandon Murphy, Mr. Parker.
Brandon or something.
Oh, Brandon. Of course it is. Brian.
Thank you, Barbara, for the gift of membership. I appreciate that.
Are we going to go and count one only?
Yes, yes, sir.
What would be, what are the sentences in all of those 2022 cases? There's 1, 2, 4 from that same date.
We got 2 years, 6 years. He's
So still on parole.
Yes, he's still on parole. He's a parole.
I guess I'm just looking at the agreement and having some
There were some
concerns.
There were some issues just for the court that of how they charged it. Normally it would have been unlawful use, UMV, but there's some evidence that the girlfriend may have been the one that took the car. She was the one that was driving the car whenever he was actually stopped, or when they were stopped. So there's.
Okay.
There's a hurt spill.
Okay. All right, that's what I need to know. And will he waive the formal reading of the indictment?
He will, Your Honor.
And sir, is it Brandon Murphy?
Yes,
And Mr. Murphy, in cause number 25, DCCR 1678, the state's elected to proceed on count 1 only. It alleges you committed the state jail felony offense of theft of property from August 16th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
yes,
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? Speak up.
yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes,
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
yes,
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Mr. Murphy's not competent?
Thank you, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of theft of property. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, good luck to you, sir. You can go back with the bailiff. Jaden Simon.
Barbara, thank you for gifting a second membership. I know you're trying to target somebody. Doesn't look like you were successful, though, but thanks for trying.
Good morning. You're Jaden Simon. Give me just a second.
And Your Honor, just for the court, there's two different cases, and the state filed a motion to stack. And I didn't reflect that on the deal because it wasn't part of the plea offer, but I've explained to him that that's the intention of the state if they go forward.
That's correct.
Okay, so the offer is
20
for
cc.
to run concurrent. Okay. All right, and so Mr. Simon, in cause number 25 DCCR 1760, you're charged with the first-degree felony offense of aggravated robbery from October 10th of 2025. And what that means in that case is that if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
Then in cause number, hold on a second, it's not right here in order. '25 DCCR 0918. Sorry, y'all. You're charged with the second-degree felony offense of robbery, and that's from June 12th of 2025. In that case, what that means is if you go to trial, the range of punishment is between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Parker's that shows that the district attorney's office has made offers in your cases if you wanted to enter pleas of guilty for 20-year term in each case, and that would run concurrently, which means together at the same time. You have every right to reject that and have your cases set for trial. I do want to make sure you understand what your options are and what the possible consequences are if you go to trial. So in addition to also those two, because your offense dates are on two different dates, what that means, and the state has filed a motion, is that if you are found guilty in both of those cases, then they could ask me to run those sentences consecutively or stacked on top of each other. I want to make sure you understand that, and that what the offer is for those to run at the same time. Do you understand all of that?
Yes, ma'am.
And Mr. Coleman, is there any reason to believe that the offers in these cases would change after today?
Not at all, Judge.
No evidence you're waiting on or anything like that?
No, Judge.
So, Mr. Simon, I also want to make sure you understand that after today, I will not accept this plea agreement. If you change your mind later and want to enter a plea of guilty, it would be to something different or open to the court. Do you understand?
Yes, ma'am.
And do you want to reject the offers and have both cases set for trial?
Yes, ma'am.
All right, we'll get those set for trial. And Mr. Simon, Mr. Parker has been appointed to represent you on your cases, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I could release him and appoint a new attorney today that could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Parker, you're released. Mr. Simon, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.
You can go back with the bailiff. Kelsey Wilson.
Michael, thank you for gifting a membership. You can actually see Michael tonight on this channel along with myself and Ashley and Austin on Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, so check that out. Barbara, thank you for gifting another membership. And Grandma TCF, thank you as well.
Mr. Lewis, you have William Jones. It's like 4 cases.
William Jones.
William Jones. William Jones.
And there's not paperwork on these.
No, ma'am.
Come on here, come in.
So all four of them, right? Category 4 offer. Same place.
William Jones?
Good morning, sir. Are you William Jones? And in cause number 25 DCCR 1627, 1628, 1629, and 1630, Mr. Jones is charged with theft of property with previous convictions. And what is the announcement?
Judge, on this, when I talked to Mr. Jones about this situation, I do need to do a little bit more digging into his priors as well as go over some of the discovery with him.
Okay.
So I'll do that for one more reset.
Sure. Any issue?
Okay.
All right, we'll just do a normal reset. Mr. Jones, Mr. Lewis will be out to see you to go over everything, and we'll get an announcement at the next court date. You can go back with the bailiff. And Crystal Julian,
Yes, ma'am.
and this one we're just going on one of them.
One of them. Yes, ma'am.
And are there priors we're going on?
Yes, there are 2 state jail priors, Judge, that will enhance this to a third.
Okay,
And they're
perfect.
both over 10 years old.
Thank you. Good morning, ma'am. Are you Crystal Angel Julian? Yes, ma'am. And will your client waive the formal reading of the indictment? Ms. Julian, in cause number 25, DCCR 1393, you're charged with the state jail felony offense of burglary of a building, and that is from June 26th of 2025. Your indictment alleges you were previously convicted of burglary of a building in 2 cases, state jail felonies, on August 27th of 2012. And after those were final, you were convicted of possession of a controlled substance, a state jail felony, July 10th of 2015. And how do you plead to those charges, or that charge?
Guilty, ma'am.
And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would be a dismissal in cause number 25, DCCR 1394. You would also be ordered to pay restitution as determined between now and sentencing, and for both of the cases, even
Yes,
the one
ma'am.
that's dismissed. You understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1. It's admitted. Is there any evidence that Ms. Julian is not competent?
No.
Ma'am, I'm going to find that you entered your plea of guilty and true to those priors freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That will give me more information about you and your cases, and then we will come back later for sentencing. I'm not inclined to do anything with the bond. I want to make sure what was going on based on that history, if there's any other substance abuse or cognitive issues that need to be addressed at sentencing. All right, you can go back with the bailiff.
Thank you, Judge.
Thank you. Ms. Holmes, you've got Otis Wilson. Good morning. Any no paperwork on this one?
Yes, we did paperwork.
Do you have Otis Wilson paperwork?
Yes, ma'am, I'm sorry, I've had some issues. Judge, it says you have it. It's corporate rules, so you should get very hot.
Oh, there it is. Sorry, that was, all right. You are Otis Crawford Wilson?
Yes.
And will your client waive the formal reading of the motion?
Yes, Your Honor.
Excuse me, Mr. Crawford Wilson, in cause number 20-34521, I have a motion to revoke your community supervision. It shows that you were placed on probation October 21st of 2020 for the third-degree felony offense of escape while arrested or confined, and that was a 10-year term in prison that was probated for 6 years. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation. Count 1 alleges that you failed to provide verification of performing the community services directed. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Thank you. Count 2 alleges that you failed to pay your court-assessed fees as directed. As of September 22nd, 2025, you were $3,550 behind. And is that true or not true? And then count 3 alleges that you failed to enter and successfully complete the JCDI program as required. And is that true or not true? Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Crawford Wilson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you, sir. You can go back with the bailiff.
Thank you.
This is our good friend, Horderman.
No, thank you.
You waive your right to a lawyer?
Yes, sir.
Please tell me that there's been substantial progress on the property. I'm talking to the prosecutor.
Okay.
I would define it substantial, Your Honor. I did have a department, somebody took photos from the street on Thursday. It shows the boat, the amount of the vehicle, the trailers. He got a large delivery of wood that is now in front of the property. There's junk along the side. I do have those photos if you want to take a look at it. I do see that the trailer in the back of the property is full. Mr. Boyd did say that it was full. It just needs to be cycled out and he needs to keep working on it. He also has not obtained a demolition permit yet for that dangerous building back in the back.
I don't know what to do with you.
I don't know how long it's good for, so I'm waiting and, I can't get the trailer out because the guy went up deer hunting and then he's up north with his boss working on.
Those trailers,
cabin,
Whose trailer is
so he's coming
that?
back.
Whose trailer is that?
The dumpster.
Yeah,
Wait a minute. So it's being used as a dumpster, the trailer is?
the trailer is a dumpster.
Okay.
There's a large red dumpster, you can see in some of the photos.
Yes.
That is full, there's still all the trailers being used as storage essentially though on the property.
What are you doing with the boat?
Trying to sell it. Got a for sale sign on, got it out by the road.
How long you had that up for sale?
Well, it's the middle of winter and
No, I didn't ask you that. I just want to know, can I have
Oh.
another page, second page to a register of actions?
since,
I think it's been about September or October, you know.
All right, talk to me, not to her. You smell.
No,
I'm
it's
just-
in November when we put it out.
I mean, it does look a little better. I'll give you that. But you still gotta get the boat out and you gotta get the
Yeah,
garage torn down.
I've had the flu since Christmas.
What's in the trailer?
I believe that Mr. Boyd has taken property out of the garage and that's what's in the dumpster.
Well, no, but there's a trailer. Is this not a trailer? This black, it looks like a black trailer to me.
Yeah, there's about 2 or 3 trailers on the property, they're just full of, excuse my language, junk. So those need to go, you can't use storage like that on the property.
When are you gonna get rid of the junk in the trailer?
A lot of it is in junk.
What's in the trailer?
Tools. I gotta put my, rototiller in there, my lawnmower in there.
Tools,
Yeah.
lawnmower?
Yeah.
What else? Is it filled up?
No,
What else do you have in the trailer?
I got some kitchen cabinets that I gotta put up
You're gonna put them where?
Huh?
Where are you gonna put them?
in the kitchen.
How long have you had the cabinets in the trailer?
November, December,
Where'd you get the cabinets?
my daughter. She,
What?
remodeled her kitchen. And, they're all handmade cabinets. They were too dark. She wants white.
Who's gonna take the dumpster out of there and take it to the dump?
The man who owns it. I rented it. $400 a shot.
Is it filled up yet?
Yeah, it's good.
When's he gonna come get that?
I'm gonna call him today, see if he's back in town.
What about the other inoperable vehicles?
The inoperable vehicle, got a broken shock, I gotta put it into
These are the same vehicles been sitting out there.
They are, Your Honor, see with the trailers, those have all been there since we did this,
I don't know what you're gonna make me do, Mr. Boyd. Mr. Boyd, come on.
I gotta work on the garage, getting it in. Everything else is secondary.
Well, that's your opinion. That's not my opinion.
We do one thing like that at a time.
Mr. Boyd.
Stop.
Mr. Boyd, I'm gonna let the prosecutor remind you how long they've been dealing with this, with your property.
Your Honor, I believe these citations date back to 2001.
So it's only been 25 years,
I didn't know about it.
Mr. Boyd. I don't know why you're not good. I don't know why you're just insisting that I send you to jail. I don't understand it.
I can't do anything to you, know.
Mr. Boyd, you're not doing anything out of jail either.
Can't do anything till.
Mr. Boyd, this has been 25 years. 25 years, sir. I was young. I'd like to go back 25 years. It's in my early 40s, 25 years ago.
Nobody come and talk to me. Except for, the guy that retired,
Yeah, what year did he come and talk to you?
just before Rob took over.
What year was that?
Last year, 25.
So you're saying you didn't know anything about this until 24? The township hasn't been bothering you to get this junkyard picked up, sir?
Well, he just come and.
Sir, I'm asking you when your first notice was from the township that you had a blight condition, they wanted things out of there.
Nobody called it a blight condition.
Sir, when did you hear from this township in reference to the condition of your property?
Probably 24.
So you guys are off by 23 years. She thinks it was 01, you think it was 24. That's one big difference. Now, I hear a lot of opposite stories here. Some people call it one, some people call it a million. I hear different stories, but that's quite a disparity. That's 23 years, not 23 days, not 23
That's
weeks.
when I got the letter in the mail. 24.
Would you look on the computer, please, for me? Can you pull up Mr. Boyd's name, please? I like you. I do,
I like you.
but I have a job.
So do I. I gotta get that.
And you're not following orders of the court.
Nothing I could do with being sick.
Mr. Boyd, you've given me every excuse under the sun.
No, it's a bad flu.
Well, let me see here. I see Robert Thomas Boyd. Allow inoperable vehicles, 2002. Improper storage, 2003. There's other ones that were set aside under a statute, building code violation 24. So they were dating back to 02. I don't know why they let it go from 03 to 24, if that's what they did. But you've had since April of 25 to get rid of this stuff. And I don't know what to do with you other than just lock you up.
I think if it was,
Mr. Boyd,
2002.
Mr. Boyd, I've had every excuse under the sun from you. I don't know how many times you've been in front of me on this case. I have had every excuse under the sun. You're sick, your boys won't help, they're too busy, you don't have the money, you gotta go to work, it's too warm, it's too cold, it's too this, it's too that. And here I am trying not to send you to jail and knowing when I don't send you to jail that I'm not handling my office appropriately. You know that? That's what I'm doing. I'm not handling, I'm just not following what I should do and what I do. So basically, somehow, some way, I've treated you better than I treat anybody else.
I appreciate it.
Well, no, but I don't want to treat you better. I feel sorry for you. I'm trying to help you. I'm trying to reason with you, and you're not taking any reason. You're just not going to listen to judges. You just don't. I don't know if you think I'm kidding up here.
I'm working on it. I've got 2 trailers full of junk out of there already. 2 dump trailers. They're big.
You got to get the garage done. You got to get the trailers out of there, the dumpsters. You got to get the junk out of the trailer. You got to make sure that your vehicles are operable, not inoperable.
Yeah,
Are they properly plated? No, they're not properly plated either, are they?
yes, they are. And they're insured.
Why did the township wait so long? If they were dealing with this in 02 and 03, what took them 21 years to start
It wasn't anything like that.
Hang on, and let me talk to her. I was talking to her. I wasn't talking to you. Why did they wait so long?
Jerry, I do know that we've issued municipal civil infractions that are handled through the township along with multiple notices.
Are you gonna deny that too?
What?
She just told me that multiple municipal civil infractions, which would not have been filed here, were issued to you many times between '03 and '24. Is that true or is that false?
I had.
True or false? Just give me a straight answer, please. I don't want to have to be a dentist today. I just don't. Is that true or false?
Well, it's not that simple.
Did they send you certain municipal civil infractions or not? It is simple. What's hard about that? It's either yes or it's no.
In 2003, I had 2 cars in my yard.
Mr. Boyd, I'm just asking you a simple question. Between 2003 and 2024, did this township send you municipal civil infraction violations or did they not? In other words, is she lying to me? Is she lying to me?
I wouldn't think so,
Okay, so she did, so they did send you notices, right?
but I have.
Right?
Evil.
Right or not? Please tell me if I'm right. I'm gonna get agitated if you keep playing with me. Did they send them to you or not?
I don't know.
You don't know?
My ex-wife picked up the mail.
Oh my gosh. You know what I want to do to that? That's what I want to do to that. That's ridiculous.
She didn't like me too much.
Boyd, you got 2 months to get everything taken care of. I'm going to give you one last chance. This is not a threat. This is a promise. I'm going to adjourn the review hearing. You've got to get, you got to do this. This is not a request. This is not a suggestion. I'm not asking you anymore. I'm telling you, this is what you're going to do. Do we understand one another?
Yes, ma'am.
The last thing I want to do is put you in jail. But I'm going to do it if you don't have the property cleaned up like I've told you multiple times. Give me a date in the end of March, Heather.
We could do March 25th, Judge.
March 25th at 8:30 in the morning. You want to take your, did you have something to say?
Just briefly, I did want to remind Mr. Boyd, I know we talked about it a little bit, is that there's a Good Samaritan with a team of people that want to volunteer to help him clean his property. It's my understanding that he says that he doesn't need her yet, that he had one person before, but I think that this is a much larger problem.
They'll help you.
Yes, sir.
If you,
I have to have somewhere to put it. The trailer in my yard, the dump trailer is full. That guy's been away for 6 weeks.
well, tell them to come and get it.
I did.
Listen to me.
He's telling me.
Take the help that the township's offering you. There's going to be no excuses next time. You understand? You do what you got to do, but I'm telling you right now, you've been in front of me on a multitude of occasions on this case, and I'm telling you, if you don't have that property cleaned up to my satisfaction in a compliance with the orders that I issued previously, I'm giving you the other remaining days, whatever they are. Do you understand me?
Yes, sir.
Take your photographs back, please. You can keep these and you can mark down what day they were taken so you can bring them next time and have updated photos. Thank you very much. Go down the hall, get your notice, sir. Good luck. I'm telling you, I'm not going to do this again. Sir, come on up to the podium and tell me your name. Your name? All right, defendant is charged with OWI 3. Do I have a detective here? I do. Detective Vesprimi, your name?
Yeah, Detective Sergeant Vesprimi at the Wooding Police Department.
All right, Mr. Crawford, we have an OWI 3 and a second charge of, let's see, Yeah, the first is operating with a high BAC with the two priors. The second is OWI third. So both 5-year felonies. How's he going to proceed?
Your Honor, my client's going to stand meet, wait for reading of the charges.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you choose to say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that? You got to keep your voice up.
Yes.
You have the right to be represented by your lawyer not only today, but at all subsequent court proceedings. Also, if you choose to submit the questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
All right. Can you afford your own lawyer, or do you wish to apply for a court-appointed lawyer?
Court appointed.
Do you work?
That doesn't work. It is home care, taking care of us.
All right. Probable cause conference you're entitled to within 14 days. At the probable cause conference, your lawyer will discuss this case with the prosecutor. If it goes that far, preliminary exam will take place 7 days thereafter. Probable cause conference will be in front of Judge Huston, January 27th at 9:15. Preliminary exam will be February 3rd at 11 a.m. At the preliminary exam, they have to show that the crime was committed and that you were the one who probably committed the crime. If they fail to prove that, you'll be released. If they fail to prove that as to both counts. If they prove it as to any one count, then you'll go to the circuit court, Criminal Justice Center for further proceedings. Do you understand that?
Yes, sir.
All right, so I have January 27th, again, at 9:15, February 3rd at 11 a.m. All right, I'll address bond, and you can put in your 2 cents, Detective. Go ahead, Mr. Crawford.
Your Honor, my client isn't a danger to the community or himself, self-position. He's asking for personal bond, Your Honor. If at home, he just lives with him and his grandmother. She's in need of regular, steady care. He provides that as part of his income. Without him being present, Your Honor, she will be in real danger, unable to take care of herself. My client's going to return back to court to take care of this. He really understands that this is very serious, so he intends to return. Your Honor. Paul showed up. Thank you, sir.
Detective Vespremi, did you contact the defendant today, or did you just go out and arrest him?
I believe he was at Wayne County and our officers picked him up from there.
What were you in Wayne County for, sir?
They called. But I don't know, I believe he was getting released from Wayne County. If I'm
For
not
what?
mistaken.
For what, sir?
I believe the probation department.
I was seated by a probation officer.
Wasn't being released.
How many prior drunk drivings does he have?
I believe there are 2, Your Honor.
18 years,
Some time ago.
18 years ago.
Looks like 98 and 2007 out of Ohio. There was a 22 where it was nollie crossed out of Taylor. Lieutenant, what was the breath or blood result? I did the signing on record, but it escapes me.
Yeah, the blood results were 0.282 grams alcohol per 100 milliliters of blood. 0.282.
Do you drive, do you have a valid license?
No.
Can you get out to Livonia?
Yes.
How?
I'm not a family member.
I can do one of two things. I can either make this easy and have you go get it yourself, but you're going to have to get it yourself, or I can order you to go to the county jail and you won't be released until you're fitted with a sober length device. Do you understand?
Yes.
So which do you choose, sir?
Lieutenant, what do you have to say? Anything else on bond?
No, Your Honor. I'll leave that to the court.
I'll give you a $10,000 personal bond. No contact with the prosecution witnesses except through your lawyer. You cannot leave the state without consent of the court. You cannot violate a law or ordinance. You must appear in court as directed. I want you going to AANA at least 4 times per week in person. And you are to be on a SoberLink device by the end of the day. You're going to talk to probation. They're going to take you over there. And that is the way it's going to be. Do we understand one another?
Yes, sir.
All right. So, Mr. Crawford, did you get him an AA form?
Just have to.
Thank you. So that's it. I'll release you, but you're going to get a SoberLink right now. Do you understand me?
Sir.
All right. Good luck.
Thank you, Your Honor.
Thanks a lot, Lieutenant. Is Trenton out there yet?
What's that?
Yes, they are, Judge.
Get him in here,
I'll bring them
please.
in right now.
Teresa Lynn Riddle, 25T642922.
Bill Crawford representing Riddle.
Thanks. Ms. Riddle, if you're there, okay.
Come here, Miss Riddle. Come on. We're going back in front of the judge.
While we wait for Miss Riddle, once again, good morning, everybody. Welcome to TCF Live. Happy Friday. If you're new out there, you're new to the channel, welcome. It's good to have you here. Feel free to say hi in the chat. This is one of the most welcoming communities on YouTube. You'll like it here. So we are in the Wayback Machine. This was yesterday's afternoon docket for Judge McNally. He was in the middle of a preliminary exam where the defendant is charged with many things, including attempted murder of law enforcement. But he is addressing a couple of matters in the middle of that. So after this, I believe he gets back to that other matter.
Get in front of the camera, stop yelling and carrying on, and behave yourself. Your
Richie
name.
Lyons brought my car out front and spilled water on my phone.
I don't want to hear it.
Last night. I need to hear
don't want to hear it. Tell me your name. What's your name?
Teresa Riddle.
Your appearance.
He's my witness that he spilled water on my phone last night.
Ma'am?
My phone was...
Ma'am, I'm going to... You know what I'm going to do if you'd say another word? I'm going to have him hold you overnight with no bond, and then we'll try tomorrow. And if you give me this guff again tomorrow, I'll just put you back in until the following Wednesday, and we'll try again. So don't be carrying on with me. I'm in the middle of an exam. I'm going to arraign you, but you're not going to carry on like this. Do we understand one another? Yes or no?
Yes.
All right.
Yes.
Now we're going to talk about the arraignment. Does she stand mute, waive formal reading?
Yes, sir.
Why wasn't she here?
Your Honor, my understanding is that some water spilled on her phone, and my interpretation was that prevented her from being able to call an Uber or whatnot to get here. But that is my best interpretation for my conversation. It's very...
Richie Lyons picked me up.
It wasn't your turn to talk. It was not your turn to talk.
I'm sorry.
Her phone got wet and it ruined her phone, and so she couldn't call. Is that what I'm just asking? Is that true?
Correct.
Couldn't call, and she was unable to get a ride. She didn't have.
She lives on Charlton. You still live on Charlton, ma'am?
No, I live at the Southland Motel
My
right now
client is
temporarily.
She's unhoused. She's staying with a friend who happens to have a room at the Southland Hotel right now. She got a P.O. box she can give the court. Yeah.
Sergeant, how did you pick her up today? How did they pick her up?
Good afternoon, Judge. Detective Sergeant Mark Driscoll. After I was made aware that a warrant was going to be issued, I was able to realize Miss Riddle was in town on our flock camera system. One of our officers located her over at Walgreens made contact with her. They were made aware of the warrant, that she didn't appear this morning as she was scheduled to, and that's where we're back at it again today.
And she was at Walmart? Wait a minute.
Walgreens, Judge.
Walgreens in
in our
Trenton?
city. Yes, sir. Can I add one thing to the phone idea real quick? And I know you're in the middle of the exam. So we have 8 from about 2 a.m. yesterday, last night, early this morning to 7 a.m. that Miss Riddle emailed council people and the mayor of Trenton to articulate an old case that she believes that we haven't investigated properly, make allegations that have been unfounded. And I'm not going to go too deep in the weeds because it doesn't necessarily pertain to this, but there's this repetitive behavior of her mass emailing and people that, if she wanted to report a
Yeah,
crime, she would, Ms. Riddle, I'm not talking to you.
Ms.
I'm not
Riddle,
talking to you,
Ms. Riddle, Ms. Riddle.
ma'am. The judge is talking to you, ma'am. Don't talk to me, talk to the judge.
Ms.
please.
Riddle, look at me, ma'am, or I'm gonna cut this off and we'll
Yes.
arraign you tomorrow.
So my point, Judge, is I believe that her phone was operational. She was able to send 8 consecutive emails between 2 a.m. and 7 a.m. to the mayor of Stratton, to several city council members. So to me, the excuse that her phone wasn't working, obviously working well enough, ma'am, I'm not talking to you again.
Stop it.
So that's just what I wanted to articulate, that we have this ongoing issue with her within the city, contacted people that she wouldn't report a crime to. Now her claim is that her phone was broken, Judge. That's where I'm at.
It was
Prepare a
wet.
forfeiture,
It got
ma'am.
By Richie Lyons,
gonna-
and I need to hear.
Ma'am, I'm gonna really lose my patience here if I already have. I'm not gonna ask you again. You don't want to show up on this case. You weren't here March 26th. You weren't here April 24th. You weren't here December 4th. I arraigned you yesterday and you didn't show up today. We're not putting the warrant in the lien, but I am forfeiting the bond. And the new bond's going to be 10,000, 10%. And if you post that, and you don't show up, you know what I'm going to do next time? I will set 100,000 cash and you will be sitting in jail until I get ready to take care of this case. This is ridiculous. You don't get to do this. Ma'am?
I have evidence.
Ma'am, I'm not going to argue with you. And that's it. We'll give you an early court date. Unfortunately, you just screwed yourself by not showing up today because Trenton isn't going to be back in front of me for 2 weeks. So I hope you can post $1,000. What, ma'am?
I need Richie Lyons here. He was the one who spilled the water on my phone when he picked me up last night.
Ma'am?
Do you believe Richie Lyons?
Ma'am, I believe that you were
He's my only witness.
I believe if you were at Walgreens in Trenton, that you could have made it here for your court date. Period.
No, my phone died. Read
ma'am.
the receipt. The receipt says
Ma'am,
that the phone was dead.
This hearing is over. You don't understand. Same bond conditions as I outlined yesterday. Now you have to post 1,000. If you want to forfeit that, that's up to you. You must have a lot of money because you forfeited a
I'm
ton of
on
bonds
Social
on this.
Security disability, and I only
Ma'am.
get a pension from
Ma'am.
Customs and Immigration
Keep your mouth
for
down.
10 years. I
Ma'am,
served.
keep your mouth down. What, Sergeant?
Sorry to bother you, Judge. I know you got a hearing. Can we put in a stipulation for her not to contact, because I don't want this to get to another harassment complaint. If she has complaints, criminal complaints, she's obviously welcome to come to the Trenton Police, but contact with the mayor on complaints.
Well, I don't know. I can't, hang on. I can't, ma'am, will you please stop looking at him?
I can't
Rolling?
believe what's coming out of his
I
mouth.
can't believe you roll your eyes and you're this disrespectful. I just can't. Ms. Merito?
I've been friends with Deb Devitt, with the
I
mayor.
don't care
I've been
who your
with them for
friends
10
are.
years.
I don't really care. I'm
I
friends with
did
Deb Devitt,
charity
but I could
work
care less.
with Deb
10,000,
and
ma'am,
all of those guys.
10%. I can't order that, detective. I mean, I can't order not that they're not witnesses to this crime, so I can't really order
Okay, Judge.
that. But you can't violate a law. So if you keep harassing them, they're going to charge you and I'm going to forfeit your bond again.
I've only contacted them one time, Judge.
I don't
Are we
want to
all
hear
set
it.
here, Judge?
I don't want to hear it. I don't want to hear it. No, what are we doing? The 29th? That's the best I can do for you. I hope you can post. January 29th will be your court date. At some point, you're going to learn to show up. January 29th at 9:45. Good luck to you, ma'am. I wish you well. Have a great day. Thank you very much.
Thank you, Rob.
All right, thank you.
Okay, friends, let's change things up a little bit. Let's go down to the great state of Georgia, Fulton County. This is Judge Rachel Krause. Let's see what she's got going on.
He'll be here by me, and just the judge can see Ms. Potter behind us there.
Okay.
Okay. So, Mr. Burke, can you hear me and see me okay?
Yes, ma'am.
Okay. So Madam Court Reporter, this is going to be a plea hearing in the matter of Maurice Burke, case number 25 SC 002-106. I'll note for the record that Mr. Burke and his attorney, Mr. Murphy, are both present in the courtroom, along with the counsel for the district attorney's office for the state, Ms. Potter. I am attending this hearing remotely. I appreciate your accommodation. I was called away on an emergency matter related to a medical issue with one of my kids, and so I appreciate your accommodating me being remote today. I'll also note for the record that the individual who might need to speak with Mr. Burke regarding probation matters and reporting instructions, including registry issues, is also attending this hearing by video. Her name is Teresa Carty. Mr. Burke, here's what's going to happen in the next few minutes. In a moment, I'm going to ask the state to provide me with either an agreement that the parties that there is a sufficient factual basis for whatever the agreed reduced charges are, or some factual basis from the state. Assuming that there is a factual basis, either by agreement or otherwise, then I'm going to swear you in, and Ms. Potter is going to ask you a series of questions to make sure you understand what rights you have and what rights you are giving up by entering this plea. Do you understand that, Mr. Burke?
Yes, ma'am.
Okay. Now, during this process, if you don't understand something or if you need clarification, you're free to ask Ms. Potter to clarify. You're free to ask me to explain, or you're free to step back and speak privately with your attorney. Do you understand that, sir?
Yes, ma'am.
Okay. Ms. Potter, let's start with this. Can you tell me I understand this is a non-negotiated plea in the sense that the parties have not come to a full resolution of the amount of time that they would present to the court, but that some aspects of the plea have been negotiated. Can you tell me what those aspects are?
Yes, Judge. Both counts are going to be modified to sexual battery. CGA 16-6-22.1. They both carry a 1 to 5 year sentence. And so we negotiated count 1, 5 to serve 3 years, balance on probation. Count 2, 5 years probation consecutive, which gives us a total of 10 to serve 3 years, with the remaining 7 on probation. Register as a sex offender upon release, get a psychosexual, follow any recommended counseling, and no contact with the victim, Ms. Perkins. And correct me if I'm wrong, Mr. Murphy.
Yes, as to everything, except there wasn't an agreement as to the time to serve. But yes, we agree to the registry, which I think is required, the psychosexual evaluation, and the any recommended treatment and no contact.
Okay, thank you. Mr. Murphy, for purposes of resolving the case today, is Mr. Burke willing to stipulate that there is a factual basis for the 2 reduced charges of sexual battery in counts 1 and 2?
We do stipulate to a factual basis, Your Honor.
Okay, thank you. Mr. Burke, will you raise your right hand? Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Thank you, sir. You may lower your hand. Ms. Potter, if you go ahead with the colloquy, please.
Yes, Judge, thank you. Mr. Burke, I know I'm behind you, but you can see me on the screen. Can you see me kind of?
Yes.
Is that okay? Okay. At this time, are you taking under the influence of any alcohol, drugs, or medication?
No.
Is there any medication that you normally take that you haven't taken today?
No.
Can you hear him okay? How old are you?
22.
And how far have you gone in school?
12.
So you graduated?
No.
No. Okay. Are you able to read, write, and understand the English language?
Yes, ma'am.
Okay. Do you understand in indictment 25 SC 002-106? The state is modifying the 2 charges to sexual battery, which is OCGA 16-6-22.1.
Yes.
Okay. And do you understand those are both felonies, given the fact that the victim was under 16 at the time?
Yes, ma'am.
Okay. Do you understand that you have the right to plead guilty or not guilty to these charges? And if you plead not guilty or remain silent, you will receive a jury trial?
Yes, ma'am.
Okay. Have you gone over all of your rights with your attorney, Mr. Murphy?
Yes, ma'am.
Have you had enough time to speak with Mr. Murphy about all the facts and circumstances known to you regarding the charges in this case?
Yes, ma'am.
Okay, including any and all potential defenses?
Yes, ma'am.
And do you need any more time to discuss the case with him?
No, ma'am.
Okay. And Mr. Murphy, do you waive formal reading of the indictment?
So waived.
Okay, and do you waive any and all defects?
So waived.
Okay. And the state is not aware of any outstanding warrants on these on this indictment or these charges. Are you, Mr. Murphy?
I'm not aware of any, no.
Okay. Judge, will he be able to withdraw his plea?
No, because the matter is set on a trial calendar, I believe.
Okay. So, Mr. Burke, this is what's called a non-negotiated plea or a blind plea, which means the state's going to give their recommendation to the court and your attorney's going to give his recommendation to the court. And then the court is going to actually decide on the final sentence. Since it's non-negotiated and we're at the trial calendar, whatever Judge Krause sentences you to, you cannot withdraw it. As opposed to a negotiated plea, if you didn't like or want to go forward with the sentence after she announced the sentence, then you'd be able to withdraw it. But you cannot withdraw it here. Do you understand that?
Yes, ma'am.
Do you understand that this is a guilty plea which will permanently be recorded on your criminal history?
Yes, ma'am.
Okay. And do you understand too that the court can sentence you to a higher sentence than what the state has recommended?
Yes, ma'am.
Okay. These two charges amount to a total of 10 years. So you're looking at a maximum of 10 years in custody. Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or violate any special conditions of probation without being subject to revocation for the balance of that sentence?
Yes, ma'am.
Okay. And do you understand you're not allowed to use or possess a firearm while on probation?
Yes, ma'am.
Okay. Are you a United States citizen?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Okay. Do you understand that by pleading guilty, you're giving up certain rights, and I'll list those out to you. That's the right to a trial by jury, the right to remain silent, not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. So essentially, by entering this guilty plea, you're giving up or you're waiving all those rights I just listed. Do you understand that?
Yes, ma'am.
Okay. Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Okay. And is it your decision to plead guilty because you are in fact guilty?
Yes, ma'am.
So how do you, an indictment 25 SC 002106, how do you plead to the modified charge of count 1 sexual battery?
That's, you have to just announce that you.
How do you plead?
Guilty.
And count 2 sexual battery 16622.1 as well. How do you plead to that count?
Guilty.
Okay. This guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
And do you understand that you have only a limited right to appeal this guilty plea conviction? For these felonies, you have 4 years from today, or you've got 30 days from today to file a direct appeal, and you have 4 years from today for this felony charge to file what's called a habeas corpus petition, and that challenges the voluntariness or constitutionality of what's going on here today. So those are 2 time limits that you must be aware of. Do you understand?
Yes, ma'am.
Okay. Thank you, Mr. Burke. That's all I need from you. Judge, as far as I am aware, Mr. Burke does not have a, the only thing I would like to add is, given the fact that the DNA results are still pending and we were on a trial calendar, the court or the state has modified or reduced this to sexual battery. The victim is okay with this sentence as she was ready to testify, and she was 13 years old at this time. Given all of those facts, Judge, we ask that you accept the 10 to serve 3 recommendation from the court And at the time the court feels it's convenient, the victim, I don't believe the victim is on, but my advocate, Ms. Kristen Clark, is on, and she has a impact statement that the victim wrote.
Okay, and now is the appropriate time for me to hear that victim witness impact statement. Ms. Clark, are you there?
Yes, Judge. My camera is going in and out, so I'm not going to turn it on.
Don't worry about it. If
Okay.
you'll do me a favor and just start by stating and spelling your name and role, and then the name of the victim, and then read me her statement.
I am the victim witness advocate. My name is spelled CHRISTEN, last name CLARKE. And I am reading the statement on behalf of Shania Jenkins. It's spelled SHANIYA Jenkins, JEKINS. And it states, Dear Judge, I was 13 in 2023. I was taken advantage of. I was touched inappropriately, and my body was touched in ways that I can't talk about because it was so bad. Every waking moment of my life, I think someone is out to get me. The defendant has caused me so much pain. I have issues with sleep because every time I close my eyes, I can envision what the defendant did to me. The defendant placed his private part somewhere he knew it did not belong. I am still traumatized physically and emotionally. The defendant took away my childhood and innocence. I always blame myself for what happened. I'm always angry and I don't feel safe around men. I hope one day he will realize the pain that he has caused me and my mom. I remember having nightmares and crying every day. I want the defendant to know I have very bad PTSD and really bad depression because of what happened to me. I'm putting my life back together slowly, and Judge, I'm doing better in school now. I pray I'm the last victim, and I hope the defendant does not ever get to do this to any child ever again. Thank you, Judge. Sincerely, Shania Jenkins.
Thank you, Ms. Clark. Mr. Murphy?
Thank you, Your Honor. Your Honor, I'll first say there was a lot of negotiation that went on with this, and I appreciate the time and effort of Ms. Potter in taking a very hard look at this case and agreeing to reduce it to the sexual battery count. I understand there was the DNA issue, but there were also some significant mitigating factors involved. Mr. Burks had just met the victim the day before. We know that it is not a defense, but he was given a different age by her, and then she came to his home with some friends the next day. So he takes full responsibility for his actions, but I do want the court to know that there were some significant mitigating factors that also go in to making sexual battery seem a much more appropriate charge that fits the facts of the case, fits the circumstances that were there, and fits the investigation that was done after the fact. Mr. Burks is 22 years old as he stands here before you, Your Honor. He is a lifetime resident of the Atlanta area. He went to North Clayton High School. He did not finish his senior year, but he is currently enrolled in a GED program as he stands here before you today. He also works full-time for Amazon in addition to that. He has never been in trouble before, Judge. He doesn't have a criminal history. So this was something that, was out of the ordinary for him. And I think he would tell you he certainly did not want to harm anyone and is here with a significant amount of remorse and contrition as he stands here before Your Honor. When I first began negotiating with Ms. Potter, I did from the outset ask that she reduce this to sexual battery, and I did with a very straight face go to her and tell her that I thought probation was appropriate for the case for a negotiated plea. She obviously objected to that, and we're here with an understanding of what we're doing, Your Honor, but I do want the court to know why I went to her with that, and it was because of the issues with the underlying case, the facts of the case, the lack of a criminal history by Mr. Burks, and the significant support in the community and family that he has. I don't know if you can see the people in the courtroom, Your Honor, but I know you've seen in the past the significant number of people that come to court with Mr. Burks every time we come before Your Honor. His mom and dad are both here. His brother's here. His brother's girlfriend's here. His sister's here. His partner is here. Judge, she is actually going to be giving birth to a child expected on August 11th of this year, Your Honor. And all of those people are here to show support for Maurice because they love Maurice. And, despite knowing these allegations against him, they stand by him. They know everything about this. They are all fully apprised of the case, know everything about it, and make sure that they are here to show up and support him at every possible opportunity to do so. Based on that, Your Honor, we are tendering the guilty plea. We do not have any objection to the full sentence being 10 years. We do not agree with the 3 years being appropriate in the case, Your Honor. We think given all the circumstances that was significantly more. I will say after we initially went to probation, Ms. Potter had a higher offer than she has come to the court with today. We did come forward and ask to do a negotiated plea at 10-1. We were not able to get there today. So we are asking the court for that. That is the sentence we are asking the court to pronounce. We do not have any objection whatsoever to the registry. I think that is required given the subsection that the plea is under on the sexual battery statute. We have no objection to a psychosexual evaluation. We have no objection to any treatment that is recommended that he will undergo diligently and be ready to do. Your Honor, we would ask if the court would consider sentencing him under the First Offender Act, given his lack of a criminal history. He does not have any prior sexual battery charges. And for purposes of the First Offender Act, a second sexual battery conviction would prohibit him. But given that he has no criminal history, he would be eligible for that. We have talked about the carrot and the stick of that at length, and he understands that and has absolutely no intention of ever being before Your Honor or any other judge ever again once he puts this situation behind him. So that is what we would ask, Your Honor, and Mr. Burke would also like to address the court as well.
Okay, before I hear from Mr. Burke, Ms. Potter, does the state have any objection to the court's consideration of that first offender?
Yes, Judge, we would object. And that is not something we even talked about during any of our negotiations.
Okay. Mr. Burke?
Your Honor, I thank you for allowing me to speak. I take responsibility placing myself in a situation I should have avoided. And I understand how serious this has been. This is my first experience, and this experience has been a wake-up call that has caused me to reflect deeply on my decisions. Since then, I have been focused on doing better. I am working a full-time job, enrolled in school, raising a 1-year-old, and preparing for another child on the way. I respectfully ask the courts to consider an alternative sentence to allow me to continue this progress while still held accountable. Thank you for your time, Your Honor.
Thank you, Mr. Burke. Mr. Burke, I just have, yes, ma'am, Ms. Potter?
Sexual battery is not eligible for first offender either, under 4260.
That's one of the reasons I asked you, because I wasn't sure, but I thought that perhaps it was not. So thank you for clarifying that, Ms. Potter.
Yes, Judge.
Mr. Burke, I have a few just follow-up questions for you, and it's mostly just to spot check what you've already been asked by the state. But you understand that you have a right to plead not guilty to these charges, correct, sir?
Yes, ma'am.
And do you understand that you have a right, if you plead not guilty, to have a trial with a jury?
Yes, ma'am.
And do you understand, sir, that at a trial, you would be entitled to be represented by an attorney, including one at no expense if you couldn't afford one?
Yes, ma'am.
And do you understand that at a trial, your attorney would be allowed to ask questions and to challenge the evidence that the state offered?
Yes, ma'am.
And do you understand that at a trial, you would not be required to testify as you're doing now?
Yes, ma'am.
And you understand, Mr. Burke, those questions that I've just asked you and most of the questions that Ms. Potter has asked you are about important rights that you have that you are giving up by entering this plea.
Yes, ma'am.
Thank you, Mr. Burke. So it appears to me that Mr. Burke has an understanding of what his rights are and that it is his intention to waive those rights and enter a plea. And so I will accept his plea as knowing, voluntary, and intelligent. And The decision-making process for how to sentence in a case like this is not an easy one. I suspect it's the same reason that the state and the defense weren't able to come to an agreement, because the nature of the offense to which you have admitted is so concerning and bothersome and problematic in our community. But I'm also faced with a young person who's not previously had legal difficulties, who has taken responsibility for those actions, and who has offered some evidence of mitigation, the extent to which, whether it's legally valid mitigation or not, but certainly factors that would have been a matter for consideration if the case had gone to trial. And so ultimately, the real question, although Ms. Potter mentioned to you that the court does have the authority, and you indicated you understood that, to sentence you anything up to the maximum that's allowed by law, which would be 10 years in custody. The court isn't going to do that. Really, the choice the court is making is between the 1 year that your attorney is seeking and the 3 years that the state is seeking. And under the circumstances of the case, given the lack of criminal history and the responsibility, the fact that Mr. Burke is here and is taking responsibility for his actions, I think I am inclined to err on the slightly lower side of that. And so what I'm going to do is sentence Mr. Burke on count 1 to the reduced charge of sexual battery under OCGA 16-6-22.1 to 5 years to serve 18 months in custody, and the balance to be served on probation. As to count 2, on the reduced charge of sexual battery as in OCGA, reduced charge of sexual battery in OCGA 16-6-22.1, I'm going to sentence Mr. Burke to 5 years of probation. Count 2 will be served consecutively to the sentence in count 1. In count 1, after the 18 months, the balance of that will be on probation. As we have already discussed, Mr. Burke is required to register as a sex offender, and he will be required to undergo a psychosexual evaluation and comply with any treatment recommendations that arise from that. And I also require that he have no contact with the victim. Mr. Burke, I do want to caution you and your family who've been so supportive of you that sometimes it happens that family members and friends have contact with the victim, thinking they're helping their family member. They're not. I'm just going to remind you that when I say no contact, that means no direct contact, no indirect contact, no social media, and no one else can contact that person on your behalf. All of that would potentially be a violation of your probation. As was discussed a moment ago, I don't know that I would be inclined to allow for first offender treatment, but I don't believe that I understand why Mr. Burke would seek that accommodation and that treatment. But I think Ms. Potter is correct that it is not allowed for these types of offenses. And so I don't know that the court needs to rule on that from a discretionary perspective because I don't think it's legally allowed. Excuse me. Beyond that, Ms. Carty had brought to the court's attention that there is some paperwork that Mr. Burke will have to sign, indicating some of the requirements of his registry. Ms. Carty, I have the paperwork I'm looking for, and this is something that I want to make sure we do correctly. I know Mr. Burke has to sign off on it, but there are a long list of potential special conditions that the court has to either require or not require. Is that correct?
Yes, Your Honor.
Okay. And so the form that I'm looking at for special conditions of probation, Mr. Murphy and Ms. Potter had the two of you discussed anything regarding the nature and scope of these special conditions? Some of them, I understand the original charge was child molestation. The victim in this case is case West 13. Some of them apply more directly. Some of them might be a little less applicable. Had you had a chance to discuss those at all, Mr. Murphy, Ms. Potter?
We have not discussed those, Your Honor. I think the only one I would have a significant concern with is his own being able to reside with his own children.
Yeah, and I would agree with you, and would strike through that requirement in subsection 2, that Mr. Burke would be allowed to reside with his own children, but not with any other children under the age of 18. However, note that that application does allow approval in advance. And so, for example, if Mr. Burke were to live with family members and had a younger sibling, or if he were to live with a partner who had a child that was not his, that can all be approved, and the court doesn't necessarily have a concern with it. It just would need to be approved. The only thing I would be striking through is any limitation on Mr. Burke's ability to live with his own children. Beyond that, I feel like the parties could probably negotiate. Obviously, he wouldn't be allowed to have any contact with the victim. That's a special condition. And I feel like the parties might be able to discuss and agree on the application or lack of application of these other aspects. For example, I don't think it's necessary for Mr. Burke to keep a driving log. But I don't think anybody should pick up hitchhikers or hitchhike, which I think is always funny to me that one's included. But I would.
I don't think to the polygraph, you can take that off.
Okay.
No driving log, no hitchhiking, no the 900 numbers in post office.
Right.
And then everything else the state would like to apply.
Okay, so here's what I'm gonna read off, Mr. Murphy, if you're aware, and tell you what I would be inclined to apply, and let me know if you have any concerns. Count 1 is contact with minors, and that would be applicable. It's sort of the main limitation. Count 2, we've already addressed, which is he would be limited from residing with a minor other than his own children. But again, that can be approved in writing if it's other children, as in the circumstances I mentioned. The residence change, and that would be applicable. The victim contact would be applicable. I would not prohibit Mr. Burke's employment. I would not apply item number 5. I would not apply item number 6, item number 7, item number 9, item number 10, item number 12, item number 18, or item number 19. The rest of them would be applicable, Mr. Murphy.
That's agreeable, Your Honor.
Okay. Ms. Carty, did you get those?
Yes, Your Honor.
Okay, thank you. I believe that would conclude this matter other than reporting instructions. And of course, we need to have these papers finalized and signed by Mr. Burke. Logistically, I'm sorry if it's going to be a little bit of a headache because I'm not physically there to have it printed for you. Are the parties able today, while you're in the courthouse, to secure the printout of those documents and Mr. Burke's signature on them so that they can be provided to the court, or we can provide them to Ms. Carty so they can be finalized? Is that something y'all can accomplish today, Mr. Murphy? I'm sorry, yes, Mr. Murphy and Ms. Potter?
Yes, Judge. If Mr. Murphy just hangs around for a couple of minutes, I'll get them printed and be right back.
Okay, excellent. And then the other thing is, in order to finalize the plea, you would need to sign the indictment indicating that there's been a plea entered. And Mr. Burke, since you've not been provided with a copy of the indictment, you have previously reviewed the indictment with your lawyer. But in order to finalize the plea today, do I have your permission to sign your name to the indictment indicating that you have entered a plea today to the reduced charges of sexual battery?
Yes.
Thank you. Mr. Murphy, may I sign your name?
You may, Your Honor.
Ms. Potter, may I sign your name?
Yes, Your Honor.
Okay. Ms. German, did you have an issue or question?
Judge, I did. My apologies. Since all parties are there, Ms. Potter, is it possible for her to print out the indictment? If not, they can just sign it since all parties are there. And once you scan back the conditions, they can be all scanned to me.
Okay.
if
I-
possible, Your Honor.
Yeah, I mean, if Ms. Potter, if you're printing something, if you could print the indictment and have everybody sign it, that would be great. If not, the record reflects that the court's authorized to sign that indictment on everyone's behalf. Anything else from the state, Ms. Potter?
No, Judge, just that we do, I guess, anticipate Mr. Burke going into custody today.
I'm aware of that. Mr. Burke and Mr. Murphy, we had previously discussed, Mr. Burke understands that he's going to go into custody today. If the deputy can go ahead and start the beginning of that process so that we can get you, get that process started, and then we'll get your signatures. And Mr. Murphy, does Mr. Burke have any time in custody previously? I mean, I'm happy he would be entitled to credit for that time if he does.
It was a very short amount of time, Your Honor. He was able to almost immediately bond out.
Okay.
I can probably tell you the exact, was it a day?
No, like 5 days.
He believes it was 5 days, Your Honor. I'm sorry.
Well, our record will reflect what time he spent in custody, and he will be given credit for that time. I just wanted to put that on the record. Anything else from the defense, Mr. Murphy?
No, Your Honor.
Okay. Mr. Burke, when you are released from custody, where will you reside? What county?
Fulton.
Ms. Cardi?
Yes, Mr. Burke, 48 hours after release, you're going to report to 276 Memorial Drive, Southwest Atlanta, Georgia, 30303. I will send the reporting instructions to your attorney and he could forward that to your family members.
Thank you.
Thank you all. That concludes this matter. And deputies, if you'll take Mr. Burke into custody, as I said, they'll be back. Mr. Murphy will be back in a moment to have signatures put on the appropriate documentation. Thank you all.
Ms. Francis, would you introduce yourself? Tell us your name and DOC number. Y'all are on mute, I believe.
Dana Francis, 458-021.
All right. Let me acknowledge the guests that we have, and then we'll get started with our process. So we have in favor, we have the Parole Project, Mr. Kerry Myers. He'll be speaking at the appropriate time. Also speaking is Deborah Sharkey, the chaplain for the Department of Corrections, or with the Department of Corrections, and then Deidre Thomas with RISE. You do have counsel this morning, so I'd like to ask your counsel to please introduce yourself for the record.
Good morning, Hannah Rose Grodell, staff attorney with the Parole Project here on behalf of Ms. Dana Francis.
Thank you. We have also with us Beverly Baker, your mother, your aunt Pamela Francis, Stephanie King, a friend, Reagan Tingle, a friend, with the Parole Project, Dimitrisi, I'm sorry, I have a hard time with that name. Moore, Christy Sheremy, Sabrina Monaco, Kim Robinson with RISE, and Jan Waters also with the Parole Project.
Just to interrupt while they introduce people real quick, I will likely want to discuss this one in the fourth hour. So form your thoughts, and if we have time, we'll definitely go here an hour 4 during overtime.
As the employee. We do have opposition who are here with us on Zoom. We have the victim's son, Jonathan Hester, and the victim's daughter, Letitia Hester, and both of those will be speaking at the appropriate time. First, let me just read some identifying information into the record, then I'm going to turn it over to Mr. Tillis. Your case has been assigned to him. So, Ms. Francis, you're classified as a second felony offender. You're currently serving a 30-year sentence. You were sentenced in East Baton Rouge Parish in September 2002 for forgery. You received a probated sentence that was revoked in 2005 for a new felony conviction. And you were sentenced in April of 2005 for attempted second-degree murder. You received a 30-year sentence. The parole eligibility date is tomorrow, your birthday. You have a good time date, February 24th, 2028. Is that information correct?
Yes, ma'am.
All right, Mr. Tillis.
Good morning, Ms. Francis. How are you?
Good morning, I'm fine.
Good. Tell us
in your own words, what did you do and what caused you to be where you are today?
First, I would like to apologize to the family for the pain that I may cause today, on top of the pain that I've caused, because I made the decision to shoot Miss Caraway, seriously harming her, and for that, I'm truly sorry. I was a 22-year-old woman staying with my cousin, sleeping on her couch, working at Microtel because I was on probation. On November 18th, I received a phone call informing me that I had lost my job. And November 19th, I took a cab to the job with the intentions of asking Ms. Caraway for my job. And upon me asking her, I became so overwhelmed with emotions of fear and anger and desperation. I shot Ms. Caraway. And I fled the scene out of shock and fear, but immediately I was so remorseful and regret, I contacted the police, confessing to the crime of shooting Miss Caraway.
Okay. Warden, do you have any comments about her?
Yes, Miss Dana is one of our minimum security inmates. She actually works at the headquarters, DOC headquarters office, and she's been working since actually LCIW took over working at headquarters. So she's been a long-term inmate working up there, which is a trusted position. We always get glowing remarks from all of the individuals that work at headquarters that she works with. Along with that job, Miss Dana actually is a mentor in our reentry court dorm. So she mentors those individuals who were sentenced to reentry court and facilitates different groups either in our cell block or in the reentry dormitory or housing unit. I think probably one of the biggest accomplishments Miss Dana had received was yesterday. She actually graduated with her bachelor's degree in seminary. So I know Dr. Sharkey will probably talk about that, but don't want to speak for Dana, but I think that was an exciting day for her yesterday. But, you know, we don't have any trouble with Dana. She really helps out where we need her to, and she stays quite busy with her job, her studies, and mentoring inmates here at LCIW.
Thank you so much. Thank you. I guess now we'll hear from Louisiana Parole Project. Mr. Myers?
Yes, good morning. Kerry Myers with Louisiana Parole Project. We're here to let the board know we've accepted Dana Francis as a client in our program. Our plan for Dana is to provide long-term transitional housing, assist her with employment opportunities, ensure that she receives all the necessary evaluations, mental health, substance abuse, and abide by those plans, any recommendations that our social workers may have for her. Dana is completely remorseful for her actions. She didn't make no excuses for her actions. The difference is the now almost 45-year-old Dana has now learned the skills and has the skills through the work that she's done there to cope with the things that life has thrown at her before and in the future. Dana has a good time release date in early 2028. This is an opportunity at her age with the skills and she has learned both vocational and social skills she's learned while incarcerated. This is an excellent time that Dana is not only employable, she shows her willingness, besides the fact that she's gone to school, she works at headquarters, she gives back community as a reentry court mentor, something that is totally voluntary on her part. because she wants to give back. She's very trusted. We would just ask this board to consider the fact the work that she's done, a degree in NOBTS, NOBTS, also attended Ashland University, also has vocational certifications, also does community service. Dana is not the 22-year-old socially ill-equipped person who made the decision to fire that gun that day. Dana can never take that back, but Dana has done the hard work, and we will support Dana on a long-term basis. So we'd ask this board to consider that today.
Thank you so much, Mr. Myers. Deborah Sharkley.
Sharkey.
Sorry.
Good morning. I am the Director of Chaplaincy Services for the Department of Corrections, as well as serve as the Director of the New Orleans Baptist Theological Seminary Extension Center at LCIW. And I've known Dana Francis since 2010. Over the past 15 years, I have witnessed a remarkable transformation in her life. Since Dana has been incarcerated, she has shown consistent dedication to her personal growth and faith and service. She did complete her bachelor's degree, and she actually completed the requirements for that degree in 2024, but we just had our commencement service yesterday, and it was a great time to celebrate what those women have accomplished. Dana has served as a peer minister, mentoring other women and providing leadership and encouragement across the whole facility. She oversees our faith-based recovery programs. That's Celebrate Recovery Inside and Life's Healing Choices. She helps women work through their trauma and their addiction. And she also teaches our pre-seminary class, Onesimus. She facilitates a helpful program called Courage for My Life. And she leads the faith-based classes in our lockdown units and also makes regular rounds in the infirmary and assisted living areas. Her ministry offers comfort and support to the women who are sick, aging, and isolated. Dana also serves on the Department of Corrections Faith-Based Advisory Council. This is she is just one of 16 inmates throughout the whole state, male and female, that were chosen to serve on this board. Dana does have some CTE vocational skills that were alluded to, but one of them in culinary arts, she likes to use in ministry to help encourage people. So what she does is she will make little snacks and things like that to build community in the dorm among the other inmates. And she often volunteers to work in the kitchen when there's a special event, even though that's not her job classification. So over the years, I have seen Dana take full responsibility for her past. I've spoken to her at length about that, and she makes no excuses. She is dedicated to continuing to grow in her faith and in leadership. She is compassionate and humble and consistently demonstrates integrity and accountability. Her life truly is a testimony to the power of God and what it means to walk with Him daily, surrendering to His will in her life. And I thank you for your time and consideration.
Thank you so much. Ms. Deidre Thomas. Did I say that right?
Yes, you got it on the nail.
Thank you.
Hi, I'm Deidre Thomas. I'm paralegal at the Promise for Justice Initiative. I had the opportunity to meet Dana as a colleague at the Louisiana Correctional Institute. At the time, I was a leader within the community, but I met a leader within the community that taught me how to be even a better leader. When I met Dana, Dana was the most humble woman that I met at LCIW. In that process, Dana has endlessly gone forward to help women in the community, whether they needed a word of encouragement, whether they were dealing with areas that they didn't want to cope with while they were on the inside. Dana helped me to see me at a different level. I stand before you today as a direct result of the board allowing opportunities for people that are incarcerated. Today, I ask that you provide that opportunity today I'm an example. I strive because of women like Dana. I had an opportunity to be her colleague in disciplinary court. In that process, when I was released, I continued to progress and maintain contact with so many strong women like Dana so that I can continue to progress. Dana, the opportunities out there for her are just insurmountable. I may not be able to offer a job to Dana today, but I would offer her and even want her to live next to me. I would be willing to open my home to Dana. Dana mentored to me, even though she does not have children. She mentored to me to mentor to my own son. She mentored to me when I dealt with depression. She mentored to me and so many people that are in this room because she learned who she is and the power that she has if she only tapped into it. Dana's relationship with God has blown me away. As her choir, we had a chance to harmonize, and we didn't know what harmony was. And I want the opportunity with so many ladies to operate continuously in harmony with Dana to help see her reach her full potential, although I think there's more that I can learn from her, but as well as to be in undoubtable truth that women that leave from a carceral setting, and no matter what they've gone through, that they can be successful and that they have a gigantic group of people willing to embrace them and to see them remaining law-abiding citizens in the state of Louisiana or wherever they live. Thank you.
Thank you. I guess last we'll hear from her attorney.
Morning. I want to begin by acknowledging the serious harm in this case. Ms. Caraway was an innocent woman, a kind woman who gave Dana a chance and was gravely injured. Nothing Dana has done or could ever do will change that. Dana carries deep remorse and regret for the pain she caused the Caraway family, and she lives with the weight of that responsibility every day. Today, however, the question before this board is not whether harm occurred. It did. The question is whether Dana has taken responsibility, genuinely rehabilitated herself, and whether the woman she is now poses a risk to public safety. Based on her remarkable record over the last 22 years, we submit to you, she has done the work, she has sustained it over decades, and she is ready for successful release on parole. I'm about to offer the following context, not to excuse her actions, but to explain the circumstances that shaped a single devastating decision that stands in stark contrast to the rest of her life. Dana was 22 years old at the time of this offense. She entered adulthood without stability, safety, or support. Her childhood was marked by severe domestic violence, addiction, and abandonment. She recalls coming back from school into the abandoned home where her mother was living, unable to recognize her mother due to the broken bones, metal plates in her body, and staples in her head as a result of being beaten while battling a decades-long addiction. Her father was entirely absent due to alcoholism, and in reviewing the trial transcript, he was quoted as saying, "I didn't want anything to do with her." She grew up in an environment where violence, addiction, and instability were constant. Despite that, Dana worked hard to avoid becoming a product of her environment. She worked multiple jobs. She put herself in school. She attended church, and she stayed away from the street life around her. but she was living on fragile footing. A prior court decision, forging a check in a moment of desperation, left her with a conviction, probation, fees to pay, and no margin for error. At the same time, she experienced a series of profound personal losses. Her grandmother, the only person who raised her and who she felt loved her, rejected her because of her sexuality. Dana had also just ended the only long-term relationship she had ever known. She had unstable housing, no transportation, and was struggling in isolation. The job she held at Microtel was not just employment, it was her lifeline. When Dana received a call that she had been fired, she didn't just hear that she had lost a job. She experienced that as the end to the only remaining support in her life. That moment triggered a lifetime of abandonment, rejection, and unaddressed trauma. It was in that emotional collapse she made the only violent decision in her life. One that had grave consequences that she is deeply sorry for. What I am here to highlight is what Dana did next and what she has done every day since. Dana almost immediately turned herself in, accepted responsibility, confessed to her crimes, and pled guilty. She didn't minimize her conduct, she never shifted blame, and over the last 22 years, she has done exactly what this system is designed to encourage: rehabilitation, accountability, service, and transformation. Her record speaks to who she is today. Driven by her remorse and her self-insight, she has deeply engaged in therapeutic programming, completing every class and opportunity that has been available to her, including multiple rounds of anger management, stress management, depression focus, and trauma healing. She understands the root causes of her behavior, particularly her rejection trauma and her emotional regulation skills, and has demonstrated sustained emotional stability for years. Dana has relentlessly pursued education. She's completed multiple advanced degree programs, including, as you heard, her most recent one, she graduated from yesterday. One only need to glance at her record to see the extraordinary amount of work she has done to break the generational cycles in her family. The Department of Corrections has repeatedly entrusted Dana with leadership roles. She's been selected to facilitate Celebrate Recovery and Life's Healing Choices, supporting other women in their rehabilitation. Most notably, she is the only offender selected and certified to teach the Moral Compass class. She mentors the mentors. She teaches them skills like decision-making, conflict resolution, and ethics. This reflects the level of trust placed in Dana. She improves every environment she's in. She contributes to safety and rehabilitation in her mentorship, in her modeling of accountability, in her reinforcing the values that this system seeks to instill. For the past several years, she's worked here at headquarters in the Adult Services Department. Staff consistently describe her as honest, sincere, and exceptionally hardworking. One staff member told me I would have no issue at all with her living next door to me. That is public safety. I have been truly moved by the overwhelming support for her among staff and administrators alike. On release, Dana will receive long-term comprehensive support, reentry support through the Louisiana Parole Project. She will be released into structure, supervision, continuity of care, stability, and a huge support network. She has built meaningful pro-social relationships within her prison community, here at the Department of Corrections and now with her family. Her mother, who's with her today, is now in recovery and facing her second battle with lung cancer. If parole is denied today, Dana will not be reheard for another 5 years. Time she may not have with her ailing mother. Granting parole in this case aligns with the goals of this board. Dana is exactly the person parole is designed for. Someone who has taken responsibility, transformed herself, poses a low risk, and is ready for reintegration. To continue the service and the transformation from inside to here. She is not the same person she was at 22. She is a disciplined, self-aware, intelligent, hardworking woman who has done everything in her power to ensure nothing like this ever happens again. For these reasons, we respectfully request granting parole in this case is not only appropriate, but consistent with the goals of this system and the interests of public safety. And so we ask, please grant Dana the opportunity to continue to serve the remainder of her sentence on parole under supervision. Thank you.
Thank you. Thank you so much. We have some people in opposition. And that is that concerns.
No, I'll
Okay.
just, no, we'll just include these in the record.
Okay, Mr. Hester,
Yes, sir.
go ahead and tell us what you would like to tell us, please.
All right. I'm going to let my wife go first, if that's okay.
Sure.
Yeah, I just want to clarify, I'm not Cindy Caraway's daughter. I'm her daughter-in-law. Her daughter was trying to get on here, but was unsuccessful in being able to be let in. She didn't want to speak, but she did want to be present and noted that she is also in opposition. I want to start off by showing you, because she can't be here today, because Cindy Caraway passed away in 2020 due to the mental illness that she has suffered from this heinous act, this decision that Dana decided to do. From that day forward, while we say it's attempted murder, actually on that day, she did kill Cindy Caraway. And this is who Cindy Caraway is, or was. And I want y'all to see her face and to remember that. Because my children never got to know their grandmother prior to this incident. She was never the same from that day forward. She didn't smile like she used to. She would spend days and awake because she couldn't fall asleep, because when she fell asleep, nightmares came. She was distant. She was a shell of the person that she used to be. My kids, my sister-in-law's kids never got to really know who she was. And she battled mental health until her very last breath when she took her life because she couldn't do it anymore. We sit here and I'm listening to everyone say about how Dana has taken accountability. I heard her say she's sorry today. That's all I heard. I heard her talking about herself just like she's always done. She was selfish. On that day, she was thinking about herself, and she downplayed it when she talked. And she said that she was fired. According to Miss Cindy, she wasn't fired. She asked Dana to come in and have a talk with her. And let's just say she was fired. You bring a gun with you to talk about being fired? Who does that? That's not somebody that went there with the intention of talking. That's somebody who went there with the intention of an action. Her intention was to shoot her. You don't bring a gun to have a talk. And while I hear everybody talk about how she's found God, I am so happy that she has, because she needed God. And I am so happy for that. That does not excuse what she did on that day and the punishment that she should have to have for that crime. God doesn't say just because you found me means that you don't have a punishment. When I punish my kid, I don't let them off early because they've made some good choices. And then we can talk about that as well. We can talk about how they said for 22 years, she's been this amazing role model. Well, records that I have received, 38 pages of it, say differently. And we can talk about those. In 2009, she was in trouble for self-mutilation. 2012, fighting. 2012, a loud argument dispute. 2014, defiance. 2012 and 2014, contraband. Theft in 2012. Aggravated disobedience in 2006, 2009, and 2015. Property destruction in 2012. Threatening behavior in 2013. She was in an unauthorized area twice in 2006. She had disobedience in 2007, twice in 2009 and 2012. And then my personal favorite, aggravated sexual offense in 2018. That does not sound like a role model the entire 22 years that she's been in prison. That sounds like somebody that was still actively not making good choices. And we're supposed to trust that she goes into parole. What if she gets in trouble again? What happened the last time she thought she was fired when she was on probation or parole? What did she choose to do? She chose to get a gun, call a cab, have the cab bring her to Microtel Inn, get out of that cab with a gun, ask the cab driver to wait for her, walk into Microtel, confront Miss Cindy and other employees in the washing area where they wash the towels and stuff, pull out the gun and point it at her head. Miss Cindy, terrified, walks out the door and takes off running down the hall. And Dana shoots her, takes the gun, puts it back in whatever she had it in, walks to the cab, tells him to bring her back to her home, where she gets out, brings that gun and hides it underneath the mattress of a baby carriage or something to that nature. She didn't turn herself in. They found her because she stiffed the cab driver and he called and reported it. What of that is fair? What of that? Like, what happens if she gets in trouble this time? I want to believe that God has made a big change in her, and I hope that he did. But that doesn't take away what she did and the fact that she should serve every single minute of her sentence, because the truth is, Miss Cindy served a life sentence with no possibility of parole. Her family has served a life sentence. We have to go each day without her here because of what Dana chose to do on that day over a stupid job. And Dana didn't apologize to all the other people it affected. Of course, it affected Miss Cindy and her family. But what about the people, the other coworkers that stood there and watched her shoot someone? What about the people that were at that hotel that heard gunshots and were probably terrified for their lives, not knowing what was going on? And all Dana was worried about was herself. And when I hear her sit here and ask for parole and all the things that she's done to make herself better, all I hear is selfishness. It's still about her. If she was truly sorry, she wouldn't put us through this again. She would take her punishment. And that would be it. If you're sorry, that's how you show you're sorry.
Thank you. Thank you.
Okay. So, look, I'm all for turning your life around, and doing what you're supposed to do. But we're all have problems in life that we deal with. Bringing a gun to shoot someone because you thought you were getting fired and you're going to have to go back to jail is not good. That day she got when she found guilty of second-degree murder. No, she committed murder. It was a slow burn. For 20-something years, I've had to watch my mom, who was the most loving, would give everybody a second chance, to be the greatest, give you shirt off their back, deteriorate in front of my eyes. We go back and watch home movies, and you can see the drastic difference from the day she was before and to the day she was shot. And life has never been the same. We talked many nights about nightmares. She would stay up days at a time because she would just have nightmares about Dana putting a gun to her head. And putting the gun to my mom's face that day and telling her she's going to shoot her. My mom runs away and you cowardly shoot her in the back, full intent to kill her. Because nobody, if it isn't premeditated, nobody has the cab wait. Nobody brings a gun. Nobody hides the gun in her carriage. When they arrested Dana, she was smiling the whole time. Just like, oh, great. We go to court that day for sentencing. She just tells us basically, it's done. Let me live my life. Well, little did she know the domino effect she created. And they sit here, it's like they're just praising how great she is. Like, she did not murder somebody. She murdered somebody. My mom. I'm happy your mom's there, and I'm sorry she's doing not well with her health and stuff. But my mom's not here because you decided you were going to take her life over a minimum wage job. To this day, I still see your face in that smile when they're arresting you.
Mr. Hester, would you address your remarks to the board?
Yes, ma'am. I still see her smile in her face that day they arrested her. The day we're sitting in court and my mom sitting there and just, you could tell she was so nervous. She threw up constantly that day because her biggest fear was she's going to have to see the person attempted to take her life, took her life that day. And to have the audacity to turn and tell the people, basically, get over it. Let me live my life. I'm all for turning your life around, rehabilitating. But we come from a world where if you do your crime, you should do your time. After the 30 years, so be it. But I have to tell my kids every day, when we watch videos and stuff, why did Mama change? Why is Mama like this now? I said, because someone decided they were going to play judge and executioner and decided to take her life. I can't tell people that my mom took her own life because that's not their knowledge. But I just had to tell people, oh, she was sick. But yeah, she was mentally sick because somebody decided they were going to take her life over a minimum wage job. Like, I'm not trying to be out of place. I apologize for my tone, but this is heartbreaking. We were going to do this a couple of years ago, right after she died, and we're trying to figure things out, but she got in trouble, so she couldn't get paroled. So to praise her and preach her for, oh, she's been a model citizen, man, we have a list. Like, we've been keeping up with everything. And who's to say she gets done and she doesn't come and retaliate at somebody else over a job? Like my wife said, if you get fired. If you do the crime, you should do the time. That's plain and simple. That's how the rule books are written. You're sentenced to 30 years. If you're good all 30 years or 25 years, you can get out of it, great. She wasn't good. She started, oh, I'm sorry for what I did to you. That person said, I'm sorry what they did to their family. That's the first time. And I'm asking you, as someone who is a father, a son who misses their mom every day, would give anything to have a conversation with her, who can't still to this day delete her number from his phone. Just please do the right thing and make her serve her time. That's all I ask.
Thank you.
Hold on, one last thing. My sister and my wife are both battling breast cancer. Well, my sister is, my wife, we're dealing with that. My mom should be here today sitting with her daughter while she battles this cancer. But no, she has to go at it alone. So I'm asking you the last thing, please do the right thing and make her serve her time. Thank you.
Thank you. Thank you. Is that all of the, the call for executive session, please?
Yeah, let me ask you a couple of questions. And then, okay. Where did you get the gun from?
I found it and I had it because of the area that I stayed in, because it was high crime and high violence. I kept it for protection because I stayed with my cousin, and we were the only female, and I would have to catch the bus early in the morning and it would be dark.
Okay. So you found it, you didn't buy it or get it?
No, sir.
From a friend, anything? Okay.
No, sir.
All right. I have no further questions.
I was going to ask the same question. I think there was something in the record that said you actually went and sought out the gun.
No, ma'am.
Okay. So I do want to, well, congratulations on your graduation and your educational achievement. I wanted to ask you a couple of things. We heard the Hester's, Ms. Caraway's family talk about your conduct record.
Yes, ma'am.
And, you know, what I have to agree with some of it is concerning, but it seems like things changed in 2016, started to change rather. And that's when you seem to be more focused. What was it that clicked in you?
Doing that
conduct record, at least. That's when things started to change.
They started to change because I knew I had it to change. And it's true, God did change me. And it was right before my mom had really got diagnosed, and I knew that I had to change. And the things that I had done, that wasn't me.
You mean the things, what things? Explain that statement.
The reports, like the unauthorized area, the defiance and the aggravated disobedience. Because I was raised and I am a person of respect. I am a person of integrity.
So I do notice you took a couple of victims programs. What did you get out of that?
When I took Victims Impact, I learned that I learned how I really affected the family mentally, physically, and psychologically. I learned that I affected my family, but even more so those that were around me that wasn't directly affected, but they were still affected by my poor choice.
So I'm just trying to get in my head as to, you know, why did you pull the gun out on Miss Caraway, Miss Cynthia? What was going through her head? And how is that?
During that time of my life, I had suffered so much rejection, and it was mainly due to my mother's drug addiction for 31 years, my father's alcohol problem. And I had just felt like so much had been taken from me. And I went that day with the intentions of begging for my job. And I just became so overwhelmed with anger and just feeling like the only person who was really giving me a chance was now rejecting me. And it was like I lost my mind, like I was out my body, like I committed a crime that I would have never done if I was in my right mind. I wasn't a violent person, and I'm not a violent person now. So coming to prison, I was determined not to be the person who fell prey to violence through rejection, where I worked on myself, where I took anger management multiple times. I learned how to deal with conflicts, and I learned how to find positive resolution. I developed coping skills where difficulties and challenges, they don't govern my emotions, they don't govern my life. And then I've developed a support network of leaders and mentors who've encouraged me and motivated me to be honest, to live in integrity, which in turn, through those things, I've learned how to mentor other women and to show them how to deal with the struggles I had as a child myself.
Okay, thank you. Mr. Tillis has made a motion for executive
A
session.
second.
We have a second by Mr. Freeman. Without objection, we're going to convene executive session to discuss confidential matters. It's 10:39. We'll be right back. All right, I'll move to go back into regular session.
Second.
And a second by Mr. Tillis. Without objection, we're back in regular session. It is 10:45 a.m. and we are prepared to vote. Mr. Tillis will be voting first.
Ms. Francis, I commend you for the positive things you've done. And I really am sorry that the family for their loss. I am. And I'm not going to drag this out. My vote today is going to be to grant to the Louisiana Parole Project.
Mr. Freeman.
Okay, I also want to commend you on everything you've done. One thing I do want to note is that you have a good time date in 2 years, so it's not actually 5 years. So regardless of what we do today, you get out in 2 years. But that family's still suffering, and it's tough. And I do realize it was totally premeditated. So my vote today is going to be to deny victim opposition and law enforcement opposition.
Yeah, there is very strong opposition in the record, Dana, from the prosecutor and law enforcement. You heard from the victim today. I agree also. Some of the things that you said to us today don't really match what's in the record about what happened. And I understand the way we process things sometimes over time changes. But I too believe that you meant to do harm to Ms. Caraway. You went there with the intention of doing her severe bodily harm. I've listened to the family of Ms. Caraway, and they are really still grieving. I'm not sure they understand what good time is. You do have a mandatory release date, which is February 24th of 2028. No matter what, you'll be getting out that day. I will defer to the victims. My vote today, based on the opposition we heard, is going to be to deny your parole. I do congratulate you on the hard work that you've done, but you've got a release date coming up in the near future. So keep doing what you're doing, mentor others. I think you can help other people. Good luck to you, ma'am. Today you've been denied.
Thank you.